Hello everyone, my name is Manjit Singh and I am a legal intern at LEXIS and Company. I am a third year LLB student of Law College. Uh, Today my topic is Zero FIR. Now let us see what does FIR mean. The principal object of the first information report, that is an FIR, for the informant point of view is to set the criminal law into motion, and that of the investigation authorities is to obtain information about alleged crime activity. First information report has not been defined under the CRPC but must be understood in the context of the provision under the section 154 of the Code of Criminal Procedure 1973. There are the few major ingredients of the FIR. Now let us look over that. Any first one is anyone who has any information about the commission of a cognizable offence can lodge an FIR. They don't need to be the victim or an eyewitness for lodging an FIR. Second one is the process is straightforward. The information has to visit a police station. Informant has to visit a police station and furnish all the information about the commission of the offence orally or in writing. Then the third one is if given orally, the police officer must reduce the information, reduce or write the information in written or authorize his junior to do so. And if non-cognizable offence, when an informant approaches the office in charge, the officer enters such information in his book maintained as per the format prescribed by the state government. An investigation for a non-cognizable offence can be made only after receiving an order from a magistrate under section 155 clause 3 of the CRPC. And the last major ingredient is the investigating power of the police officer are the same in both cognizable and non-cognizable offences. Now let us directly move to the zero FIR. Definitions of zero FIR. The concept of zero FIR is new, as we all know. It refers to a FIR that is registered irrespective of the area where the offence is committed. The police in such of case can no longer claim that they have no jurisdiction. Such an FIR is then later transferred to a police station with the actual jurisdiction to begin the investigation. It was introduced on the recommendation of the Justice Verma committee formed at the backdrop of the brutal Nirbhaya gang rape case in Delhi in 2012. This puts the legal obligations on the police to obtain an investigation and take quick actions without the excuse of an offense, without the excuse of an absence of jurisdiction. Now, let us see who can register FIR. If an offense is committed, then who are the persons can register an FIR? First one is an FIR can be registered by the victim himself or by their family or relative or any other person who knows the fact relating to the incident can also file on behalf of the victim. There are a few case laws which we can discuss and clear about this concept of zero FIR. The first case law is Kirti versus State of Odisha versus State and Odisha. It was stated that even if the information to be registered as FIR where the incident took place, which is out of the judicial area of the police station, the police is still obliged to take the information and register zero FIR and thereafter transfer to the particular police station. And the second case was is about State versus Harnam Singh, in which it was held that Harnam Singh, along with the three men, kidnaps a girl in a school uniform. Later, upon receiving an information, both were taken to the police station situated at the Parliament Street, where zero FIR was registered. A subsequent medical examination was done and taken to the police station at Tilak Nagar, where the duty officer was given a copy of the FIR. Now, from discussing all about the facts and the case laws, now we can conclude that if the crime appear outside the jurisdiction of the police station, still the police are duty bound to register the FIR as zero FIR. Technology is emerging so fast, as we all know. The online FIR is also enabled by some of the state, whereas the FIR status could also be checked virtually. In the virtually, it was stated in the case of Hathras rape case 2020. A 19-year-old Dalit woman was gang raped and brutally tortured in the field. After regaining the consequences, the victim called her family and a statement was recorded. Therefore, an FIR should be registered immediately after the offense has been committed to prevent facts and evidence loss. Thank you. Please like, subscribe and comment on my channel as well as on my videos. Do comment your questions on the comment box. If you have any question with regards to this video or with regards to my previous videos, this video does not solicit any type of promotions or advertisement as per the guidelines of the Bar Council of India. The sole purpose of this video is for the educational purpose only. Thank you.